Testing 1 2 1 2. Test test. Testing 1 2. Testing 1 2. Test 1 2 1 2 1 2. Test. Test 1 2 1 2 1 2. Test. So you can't get sweet tea around your house?
I mean, I could always make tea sweet, but yeah, I can't get official sweet tea now. Los Angeles, as I was telling them, McDonald's did for a while. That was kind of cool.
Just didn't go over well?
I guess it doesn't do it now, so I probably didn't have enough people. Anyway, so it was tasty.
All tea is sweet. There's tea and unsweet tea. At least in the South, that's what it's called. That's just tea. You have to ask for unsweet.
Oh, I know, that's right. I think I knew that. It's been a while, though.
Do you fly back home today?
Yeah.
When did you fly in yesterday?
Mm-hmm.
Wow. That's a lot of travel. You're going to be spending more time on an airplane than you were here in town, aren't you?
Yes. You know, it's people always say, oh, it's so cool you get to go so many places. Now I'm really careful.
Whenever you get ready to start?
I'm ready to start.
All right, let's go and get there.
Okay, yee-haw.
Go at it.
All right. Today I'm going to stand behind there. Last time I stood in front, but this is too technical.
Thank you.
Hi, everyone. Good to see you. Good to be back in Alabama. I'm from Los Angeles, though when I go places, I tend to get an accent. So if it starts slipping, it's just what I get everywhere I go. And I really like Alabama. It's much greener. So we are going to talk about resolving ethical issues and legal end-of-life dilemmas. I work as a clinical bioethicist out in Los Angeles. I've also been a family caregiver 6 times, so I really can understand the challenges of the patient and the family, but also of the healthcare professional. Today's talk is going to be a lot more focused on, okay, I'll just use this little button there, on the law. So let me go ahead and get started. One of the first things they wanted me to address was the question, what is an actionable medical order? Because apparently there was a lot of confusion. And the easiest way for me to explain it is usually the word order is in the heading, and also it's signed by a physician. In some states, it can also be signed by a nurse practitioner. It's different than a living will or an advanced healthcare directive because those are just signed by the patient, right? And it's just a patient preference versus an actionable order is an actual medical order that can be followed both in a hospital setting, but also in the ambulance, at a person's home if the EMTs arrive, at the skilled nursing facility, a boarding care. It's an order that can be respected across institutions. So the best thing, I'm going to go through some of the actionable orders that you have in 8 different states because you are part of a health system. And hi everyone in the other states. We have 8 other states, so I'm going to give you a little bit of information on each of those. And the main thing is if you are going to use one of these orders, is to find out from the social worker, is this completed correctly? Right? Before you follow an order, you should make sure that it's completed and signed correctly, dated, everything that your law requires. I also have given you a link to the American Bar Association. They have a nice comparison chart as of a year ago, and there's always more information out there. So here we go. So Alabama, we'll start with the A's. Alabama has the Portable Physician Do Not Attempt Resuscitation Order, your DNAR. The thing that you should notice about it is it's portable, right? So it's not just the DNR or DNAR that you're using here at the hospital. It's a form that, again, moves wherever the patient goes. Again, these are really helpful because if somebody is ill and in an ambulance, if they just have an advance directive, the EMT can't honor their wishes at that moment. They just bring them here to the hospital. But if they have the DNAR, like in Alabama, then they can respect what's on the form. In each section for the different states, I've given you a link or links to the information about the actionable medical orders, as well as a link to the other end-of-life laws in your state. So Michigan passed theirs more recently, and surprisingly, Michigan's is only valid for a year. At first, I thought that was kind of good because people should update their wishes, and then I thought, oh no, physicians would have to keep writing them every year and rediscussing it, and what if they lose capacity in that year? And then I'm like, I don't think that's a good idea. But Michigan, that's your law. And so Michigan, theirs is called MyPost, Physician Orders for Scope of Treatment. The other thing to notice is that some forms are really just about CPR. Most of the forms in the different states also include feeding tubes, level of treatment. Even some of the forms address whether the person would want to be readmitted or do they just want to stay home on hospice. So in Florida, their physician orders for life-sustaining treatment is POLST. That's similar to California. Indiana has a POST, which is a physician order for scope of treatment. Kansas has transportable physician orders for patient preferences. I cannot pronounce TPOP or something. I'm not from Kansas. Tennessee has a POST, physician orders for scope of treatment. Texas has a MOST, medical orders for scope of treatment, and Wisconsin has an emergency care do not resuscitate order, a DNR. So every state is different. So if you happen to have someone visiting and they had their portable orders with them from another state, you would have to find out from risk management or from the social worker, can we honor this in another state? They don't always transfer across state lines, but at least they're a representation of the person's wishes, even if it's not a direct medical order. The other thing to be aware of is that that order in an Alabama form or in a Wisconsin form, they are usually written by a physician that you don't know. But that doesn't mean we still don't honor them. You know, we are communicating across professionals. All right, so I do want you to consider really looking up the laws. I think one of the things that I find helps physicians the most is to learn the end-of-life laws that are in your state. First, because that will teach you what you are obligated to do. But second, it also tells you what you're allowed to do and what you're protected from. A lot of the laws actually say you are allowed to do this, and there are protections for physicians. You're not just alone out there practicing. The law may really support you in your state. I've been told that it's possible that the hospital system is actually going to create a cheat sheet with end-of-life laws for each state, and they'll be giving those out at hospitals in each area. Because again, it's hard to be up to date on everything, but I find that the end-of-life laws are not really prolific. There's not that many, and they can really support you and help you when you're dealing with a difficult patient or family. So we're going to keep talking about law, but I want to put it into the context that law matters. If there's a law, you should follow it. Right? Even if you don't think it's a very ethical law. Because ethics, something might be ethical but illegal, and there are laws that are really not very ethical, right? So if it's a medical health law, you are obligated to follow it. Whether you like it, whether you agree with the law, it's a law. If for some reason you're really opposed to participating in that law, then you have an obligation to transfer that patient to someone who will follow the law, right? You are allowed to have conscientious objection and to opt out, but don't just say, well, I just won't follow the law because I don't like it, right? So that's why it's important to know the laws of your state. So in each of these ethical dilemmas that you're facing with patients, you have the law, important to know. You have ethics, medical ethics, autonomy, beneficence, non-maleficence, all of those ethical standards. And then you have the personal. What's the person's preferences? This is about a real person, right? It's not just about law or ethics. There has to be a personal component in it. So in each dilemma, you should think about, what does the law say? What does the ethics of this situation say? And what would the patient say? I also would recommend that you use hospital policies and procedures. And again, if you're not familiar with them, talk to the social worker or risk manager or the legal department if you have a really serious question, because following hospital policy is very good for you to protect yourself, right? It's kind of a combination there. So today I'm going to be the doctor. I am not a doctor, I'm just playing one on the talk right now. You are my patient. Hi, patients. Hi, patients in other states. So you are the patient, so really kind of embrace this moment. And you said no. no feeding tube, no dialysis, no antibiotic. Whatever the no is, you said it. And so I want to ask you, if you said no, did you actually mean it? And should I respect it? Should I respect your refusal? So does anyone have an advanced healthcare directive or living will in this room? Does anyone have one? Raise your hand. About 8 of you out of like 40. That's not good. You should all get one. And you guys in other states, you should be raising your hand too and check who has them and not. Okay, so do you want me, the people that have completed their form, do you want me to respect the no? If you wrote, you actually want me to respect it. You don't want me to just go, oh, look at this. I don't feel like following it, right? Or if you told me no, you want me to go, got it. You have the right to make your own decisions, and refusals are absolute, okay? So is anybody here okay with me ignoring your no that you told me? Anybody? Good answer, right? And so if it's in your directive, if you told me specifically, even if you wrote your directive a long time ago, if it's in writing, no means no. All right? And what if, here's another example. What if you told someone in your family what you might want, and you said, wow, I would never want blank. And I would assume a lot of nurses have strong opinions about that. Nurses are usually the people that have the strongest things. No, don't keep me on that vent. No, don't do this. So if you told your relative, should I listen to that relative? Raise your hand if you want me to listen to your relatives. Only 4 of you, 5 of you. I don't know about your relatives. No, you know, this is the area that it's a little messy. If the patient directly tells you and they have capacity, yes, honor the no. If they wrote it in their medical orders or in their advanced directive living will, follow that instruction. When we're talking to a family, we want to make sure we feel confident that we're getting good information from the person who really should be the decision maker. Again, those rules are different in every state. There are times when we might say, I don't know that this person isn't putting their agenda in there, right? Because sometimes family will say, I know what she wants because it's what they want, right? But in general, no should mean no. Do you know, here in Alabama, is there a law in your state that says that surrogate decision makers have to honor patients' wishes? Apparently not. Wait a second, I'm looking. One person looks confused.
On the advanced directive form we give here at the hospital, the healthcare proxy, there's a couple boxes to check.
Right.
Like the patient can say, I want my healthcare proxy to follow my wishes no matter what.
Got it. Okay, let me just mention this for everyone listening. So on their hospital, their advanced healthcare directive living will form, there are boxes saying, I want my proxy, my agent, to follow it explicitly. They have some flexibility. They have the space to adjust it if the situation is different. But is there an actual law that says decision makers must honor patients' wishes? So in my state, California, we have one, and it's Probate Code 4714. And it's very helpful to know that number because when I'm dealing with families, I can tell them that. So if you don't know whether or not your state has a law, I would encourage you after the event today to find out and then to just remember the number. You don't have to remember the words exactly from the law, but just knowing that there is a law and that there's a standard that way can a lot of times give you some support, right? And so apparently you don't have one here in Alabama. A lot of states don't. Just wondered. Okay, so what about case law? What's the difference between probate codes, like laws that the legislature or the public pass, versus case law? Case law are legal cases that went through the court system, and they went through the appellate process far enough up that everyone can agree, or most people agree, that yeah, enough courts have agreed that this is true, so therefore we will abide by it. And a lot of times it's tested in different courts, even in different parts of the country. There becomes a standard that we live by. So case law isn't necessarily specific to your state. It's in health law, it's more of a national point of view. Okay? So I'm sure you've heard of 2 of these cases, but I just want to remind you what they were, why it was decided that way, and what the case law actually says. Okay? Because again, I think that strengthens our confidence when we're dealing with difficult people. So this was Ann Quinlan's case. This was 1976, which is a long time ago now. We started getting ventilators in the 70s, so this was resolved in 76. It started earlier than that. It was one of those early ventilator cases. It went through all the way up to the New Jersey Supreme Court, and here's what happened in the story. Ann Quinlan, she was using drugs and alcohol at a party, and she had 2 15-minute anoxic events. She was comatose, and then over time she presented as persistent vegetative state. Her father wanted to be made the guardian so he could make the healthcare decisions and turn off the ventilator. This wasn't like right away, but you know, she hadn't gotten better, time had gone by, and he wanted that opportunity. Well, again, it went through the lower courts, the next ones, and after many years, the court allowed the withdrawal of the vent. What actually happened, though, at the hospital is the physician was very unhappy with this because, again, it was so new. We weren't comfortable actually turning off a vent, so the doctor weaned the person really slowly, and she ended up living for 10 more years off of the vent. And so what did the court actually find? The reason I want to mention this case is for you to know where some of the standards that we live by in medicine come from. This is some of the actual law from the findings. The individual's right to privacy grows, and the state's interest weakens as the bodily invasion increases and the prognosis dims. And this privacy, this right to control your own body, extends to healthcare decisions even if they may end up in death. So it said that you're allowed to say no, and over time it's even been modified to include more things, and I'll show you those. It also was the first case that says the act of withdrawal is legally equal to withholding. So if you take someone off a vent, that's the same as not starting them on the vent. Right? A lot of times people say, well, we already put her on it, so we can't take her off. No, the law says that not starting it or stopping it, legally the same. Okay? The other thing that this lawsuit gave us was the fact that a surrogate decision maker can decide to withhold and withdraw. The last thing that this case really gave us was that kind of language we use where we say to the decision maker, what would Bob say? If he could understand what's happened to his body and his health, what would Bob say? They actually addressed that in the lawsuit, that they said if Karen were herself miraculously lucid for an interval and perceptive of her irreversible condition, she could decide upon discontinuance of the life support. Right? So the practice that we already do actually came from somewhere. It's not just what we do, it's case law. All right, so what about the case law regarding withdrawing or foregoing artificial nutrition and artificial hydration? Now again, you may have strong personal opinions about what you would want for yourself or even what you think others should do, but I'm showing you what the law is, and that is, we have to follow the law. If you notice, I didn't write withdrawing and withholding. Listen to the difference between withholding and foregoing. If I'm withholding something from a patient, it's like I have it and you can't have it, right? I'm withholding it. Versus the patient in their directive, or the patient told us in earlier conversations that they would want to forego this. One is me doing it. Another is the patient choosing to forego it. Very different emotional reactions to that kind of language. Also, I mean, some people are adjusting their language to medically prescribed nutrition because that's more accurate. It's not food because it's not Thanksgiving dinner, right? It's not apple pie and pumpkin pie. It's medically prescribed nutrition. So depending on your language and how you choose to use it might affect people's perceptions. So this was one of the first large cases that happened regarding people having the right to forego or withdraw feeding artificial food, nutrition and artificial hydration. Bouvier, Miss Bouvier, was a 29-year-old woman with cerebral palsy. She was a quadriplegic, completely bedridden, and in constant pain. Interestingly, she wasn't terminal. Most of these cases, usually they're terminal in these early cases. So what did she want from the courts? She wanted the right to have her feeding tube removed, and she also wanted to stay at the hospital and have them take care of her while she died. Now, this is back in the earlier 80s. It resolved in 86. The nurses were really unhappy. Like, I don't feel comfortable. We don't have laws saying that I can stop feeding you and watch you die. Nowadays, we'd put them on comfort care. We would put the person on hospice and discharge. So again, things change over time, but this was through the Supreme Court of California. What did the court decide? They said that a non-terminal, competent adult can refuse treatment even if the refusal will lead to their death, and that patients have the right to stop treatments, but she could not force the hospital to take care of her. Interestingly, after she got this right, she never exercised it. She chose to keep her feeding tube, and she lived for a period of time after that. I find a lot of people want certain rights. They want the right to control their destiny, but once they have it, then they feel like, okay, if it gets worse, the pain, then I will, I can use that, but I might not, right? She wanted the choice. One more case, the other most famous case, I'm sure you've heard of this one, Nancy Cruzan. This went through the Supreme Court and it resolved in 1990. The story began in 1983. Nancy Cruzan suffered an anoxic event during a car accident. Again, she was comatose and then became PVS. Initially, with like so many head traumas, there was hope, right? We hoped that she would get better. After years of artificial nutrition and artificial hydration, her parents asked to have the G-tube removed. And this went through the court systems. There were huge battles in Missouri. Ultimately, the Supreme Court said that patients have the right to, actual language, patients have the right to refuse life-sustaining treatments, and this right is worthy of the highest protection of the Constitution. This right to refuse includes the right to withhold or withdraw nutrition and hydration. Right? So the reason people can say no and that we're supposed to follow it, very old case law, which in many states has been codified into probate codes, right? But it's hospital policy, it's medical standards. So this has been the law. I want to take a moment and show you something personal, right? Because we have the law, we have the ethics. You may not agree with the ethics of these laws. Here's the personal. This is her headstone. This is Nancy Cruzan. Her family put on there, she was born July of '57, departed January of '83, at peace December 1990. I found that interesting that, you know, we look at these laws and these situations like they're just laws, but they really affected a real person. Right? So again, when we're thinking about decision making and working with patients and families or guardians, conservators, we want to consider all the categories: law, ethics, and personal, and hospital policy. I guess I should add that one on the slide. Okay, so now we know that refusals tend to be fairly absolute unless somebody's telling us and we're like, I don't know that you you actually had this conversation with your relative. Here are some reasons people will give you to not follow their relative's post or directive, whatever their document is. Number one, I want you to tell me, should we listen to this excuse or this reason and ignore the directive? Well, she wrote it a long time ago. How many of you wrote your directive a long time ago? Oh yeah, hi in the back, so that means I should just ignore it, right? No, you're shaking your head a lot, right? Okay, so that's not a good excuse, okay? How about she wrote it before she got sick? I can kind of understand that because we a lot of times write these when we're healthy. You know, it's one reason people should revisit these decisions, like every maybe 5 years, they should reevaluate their directives. But as the professionals looking at the document, it's legally completed. Yes, she wrote it before she got sick. It's still a legal document, right? Even though all those things where we might say, but, it's a legal document, okay? She didn't know what she was signing. This one does concern me. If you have somebody that brings in a directive or there's a post, etc., or post or my post or T-pop, okay, if you realize this person has advanced Alzheimer's and she signed this 2 weeks ago, she did not have capacity. Or you're concerned because you don't think that she probably had capacity when this document was completed. It's not necessarily for you to determine, but you should talk to risk. You should bring this to the attention of the legal department at your hospital. Because if you really think that she didn't know what she was signing, that might be a reason not to honor that document. Also, if you think that this person was being coerced or there was elder abuse, right? Because there's a lot of people that say, oh, grandma's really sick. Let's take her to the elder law attorney or the probate attorney and get her to sign away her life and her directive, and I'm in charge now. And grandma should not be signing documents. Okay, so if you really think that there's a concern, then bring it to legal. This one is a little more nuanced. Even though she said she wouldn't want to live like this, she's happy, right? I mean, and I can understand that, you know, maybe we could say, well, if she could see how her life is now, what would she say? But I always come back to the fact that it's a legal document, and so we are supposed to follow it. You know, again, maybe that's why people check that box saying, except if the situation has changed, I trust my loved ones. Well, they might not be loved ones. Not everyone likes their relatives. But, you know, that might be a difference. Okay, my favorite of all of them, should we honor it if the family says to you, I'll sue you if you honor what she wrote? This is intimidating, right? Because no physician, no professional wants someone to say, I'm going to sue you if you don't do what I say. That's when you have to feel very strong and say, no, it's a legal document. I must honor it. I have obligations. That's why it's good to know your obligations and also your protections. I will tell you that you are much more legally liable and vulnerable if you go against patients' stated wishes than giving in to a family that's telling you to ignore that document, right? Doing the right thing and following the document, good. If you give in to this person who's bullying you, and I know these families can be really challenging, you may be vulnerable. And I want to show you some legal cases that are happening all over the country. And these legal cases, this is just 3 as an example, they're happening everywhere. Physicians and hospitals are getting sued because they went against the patient's stated wishes, whether it was documented in the chart during a previous conversation or they're actually written documents. Thaddeus Pope, he is the most expert end-of-life lawyer in our state, in our United States. And this is one of his big concerns because these cases are popping up everywhere. So this first one is called In Regarding Levatas in New York. The court removed a demanding surrogate because the demands went against the person's stated wishes in the advance directive, and the lady failed to appreciate her mother's true medical condition. She was in such denial, she didn't understand, so she wasn't making competent decisions, and she said, "You've got to do what I say." So, doctors, hospital gets sued, they all lost this suit. You have to honor the wishes. Cardozo versus USC University Hospital, they're affiliated with USC Medical School. The surrogate's sister sued because the other sister, who was the surrogate, was not complying with the directive. And she's like, "Why are you ignoring my mom's document?" Right? She wrote it down. Why are you asking my sister, "Do you want me to follow this?" USC got sued, the doctors got sued, everyone lost that case. Bernstein versus Superior Court, a conservator was replaced because of demands for aggressive care that offered no benefit and significant suffering. So I just want you to be careful. Again, I don't expect you to be a legal expert. I would encourage you to become more of an expert and learn the things that apply to the work that you do. But that's why you have resources in your state, in your hospital. You have experts you can turn to. Don't try to solve these things by yourself. So now that I've given, oh boy, all these poor families a hard time, right? And I've actually been the difficult family member. Mostly I'm quite helpful and cooperative and a good team member with the professionals when I'm in that role as family member. But there are times when I am so overwhelmed, tired, been up all night, just drowning with the idea of being a caregiver, that I'm not at my best self. I work about half of my time with hospitals and physicians. The other half I spend teaching out in the community at conferences, teaching families to become better decision makers. And one of the things I developed was actually a word that describes the grief and loss we experience when we are this overwhelmed family caregiver. I call it care grieving. And this care grieving is long-term suffering. It's not just grief, like somebody dies, or anticipatory grief, we know they're about to die. Some of these people have been caregiving for 10 years, 18 years, and if they're caregiving for someone with a serious chronic illness, dementia, it can be really overwhelming. And their emotions and their ability to cope and cooperate nicely with you are really at their lowest level. These are some of the things that people tell me, how sad they are. They burst into tears, they're angry, they're resentful that their life has completely changed. They're spending all their money taking care of this person and their family. They're lonely, right? My spouse is here, but not really. They're in shock. Every time you give them bad news, it's just another day for you. Every piece of bad news is another shock to their system. So I think for me, I think it's important that we try to approach these difficult families with some compassion and some humanity and humility, that we don't know what they've been going through. They're not usually trying to be difficult to make our day more difficult. They're just drowning with what they're going through. And it could be emotional, it could also be physical. One of the consequences of being a family caregiver is a lot of us die early. Is anybody here a family caregiver also besides your professional role? And has anyone been a family caregiver? Yeah, not easy, right? They did research. Research was done on parents of chronically ill children. And they found that those parents died, I believe it was 6 to 8 years sooner. The range in all of these studies is 6 to 10 years. Then they said, wait a minute, if that's happening with parents and chronically ill children, what about adults, people taking care of someone with long-term illnesses? They found that those people were dying sooner. And then they said, why? And what they found is that our DNA is literally aging faster. Here, let me just read this little bit to you. They found that the telomeres in blood cells of caregivers were shorter than those of the controls, and that the telomerase repair enzyme among caregivers was also lower. Caregivers also had fewer lymphocytes and higher levels of cytokinins affecting their inflammation. When I first heard this, remember, I've been a caregiver 6 times, I'm like, whoa. I have probably damaged my long-term health, right? So when you're talking to someone like me and I'm not in my best state and I'm overreactive and I'm in fear and exhaustion, realize that it's not just that I'm difficult. I actually am deteriorating. The good news for those few caregivers in the rooms, because you're all freaking out right now, is that if you get some exercise, have a community of support, eat a little better, all those normal healthy aging things, you can improve your telomeres. Okay? Now, there are families and people and patients that are truly evil. And, no, I'm serious. There are people who are horrible and not just tired. But a lot of these people who are difficult, they really just need our help. You know, and so as much as you want to disengage, like, oh, that's a difficult family, I don't even want to go in that room. They still need us. Maybe they actually need us even more. Don't take your frustrations out on that family. Maybe the first day they were there, they were so scared and they were so reactive. Maybe today's better. Right? And I know that professional caregivers, doctors, nurses, pharmacists, you're getting burnt out. I wouldn't be surprised if your health is being affected from all of the stress of your jobs. Get support for yourself. Still don't take out your frustrations on the patient. Don't ignore problems. The sooner you can deal with things, the better you'll take care of it. If you let something fester with these families, it's going to get worse, and it's going to get harder and harder to solve. Ask for help. You have ethics committees. You have social worker, chaplains. You may have other patient advocates, patient representatives. Sometimes all it takes is sending in a different social worker, right? A new face, a fresh face can really help. Listen to the story, because maybe there's a lot of other things going on that you didn't know. And when you hear it, you might change your mind. So one of the best openings that I've ever learned for dealing with these complicated end-of-life conversations and family conferences is something that I learned watching Daryl Owens from Seattle, Washington in practice. He's an amazing palliative care specialist. In general, we're taught as professionals that we should give the medical information. Here are the labs, here's the new x-rays, here's where we are medically. Now let's talk about what we're going to do. It's not what he does. Instead, it's magic. I will tell you, it's magic. I've seen it in action. He sits down. Doesn't bring up medicine yet. He makes it personal. He says, you know, I don't know Bob outside of here at the hospital, right? I know him as a patient, and I worry about him, and I care about him, but I don't know what he's like at home. Like, what does he enjoy doing? How has his life been this last year? Who is he outside of this hospital? And then he sits back and he listens. And the person might say, Bob loves his dog. And I will tell you, Bob, my brother, he has the ugliest dog you've ever seen. His dog is so ugly, but Bob loves him. I mean, I'll show you a picture. It's so ugly, right? I mean, because all of a sudden, do you feel how different this conversation already is? This is not conflict. This is not death and dying. It's personal. And the person might say, you know, Bob loves his grandkids. Bob loves to work in the garden. And you let them tell you. What this does is quite a few things for you. One, it helps build and repair trust. Even if things haven't been going well, sitting and making this person not a body in the bed, but Bob, a real person, humanizes the patient for us as professionals, but it even humanizes them, the person, for the loved ones, right? Because a lot of times we get so caught up in all of the medicine, we're not thinking about Bob with his dog. It also can help families get out of denial. Not completely, but it opens the door, because as the loved one is saying, Bob loves his dog, in their mind they're also seeing Bob with 5 tubes in them in the ICU. Bob at home with his dog, Bob in the bed. And it just opens it up a little bit. It also provides information that you can use when you start talking about medicine, and then you're going to contextualize Bob and his preferences into the medicine that you can provide. Right? Because medicine has to have a purpose, not just a medical purpose, but a purpose for this person. Right? So you might say, you know, we could do dialysis, but Bob is never going to make it home to see his little dog. He's going to be living in a subacute. Bob won't be able to work in the garden even though we do this surgery. Now, that doesn't mean there might not be other things that are important to Bob. I'm not saying that's all that's important, but it works really well because you're breaking expectations. You're tempering their expectations, which is great. They're going to cry, you're going to be uncomfortable, but that helps because they think that the magic treatment you're offering is going to do the trick. And you know it's not. Maybe there are things you can offer. You can say, I can't, these things won't help, but we could do this. And it will help them get back to what is important, okay? This, I have seen Daryl take families who are in total chaos, angry patients and families, and with that first sentence and that first 2 minutes of conversation where he just sits and listens, it changes everything. So it's just a technique you can use at a family conference. You could also use it early on in the discussions so that the people know that you really care about Bob. Okay, so we've talked a lot about no's. We've talked about the family. What if, hi patients again, what if you're the patient and you said, yes, I want dialysis. Yes, I want a feeding tube. Yes, I'd be okay on a vent. Did you really mean it when you told me yes? Yes? If you wrote yes on your directive, did you mean it? Yeah, yes, sir. I see your head. Do you want me to actually follow that? Yeah, right? Okay, good. The same kind of rules apply. I know that sometimes ethics and law seem so complicated, but this is a way for you to kind of run it in your own head. Like, wait a minute. If I were the patient and I had written it down, would people want us to follow it? And there's a law, but I mean, it helps you kind of process. What if somebody I said to my relative, I would want this, right? It's that kind of the same rules. Can your family say no even if you said yes? It's a little messier. No is nice and absolute. Yeses are a little messy because maybe the treatments that you said yes to aren't actually effective. They're not the right plan anymore, right? There are times when what I thought I would want at that point because it would help me, I didn't know I'd have a stroke and I'd be in a lot different condition, and those treatments would no longer be effective. So can family go against your yes? Let me show you a new policy, some of you may already be aware of this, that you may want to incorporate or at least learn from in your hospital setting. Number one, no matter what state you're in, high 8 states, use your state law. you may or may not have a law that says we do or don't handle medically futile, ineffective, non-beneficial treatments in this way. In fact, Michigan's form, it actually says that even if the form requests medically ineffective treatments, the doctor can evaluate and say, no, I know you wanted this, but it's not good medicine. That's their new law. Look at your hospital policies. If you want to know what some of your states say, you can go on the website there. Use your ethics committee. Update your policies. And this is something that I would encourage you guys to take a look at institutionally, but even personally, because I think not only is it a lovely policy approach, but also just the insights and the way they describe these situations is very helpful. So this is a policy statement responding to requests for potentially inappropriate treatments in the ICU. And if you notice, it's a combination group that put this together, the American Thoracic Society, the American Association for Critical Care Nurses, American College of Chest Physicians, European Society for Intensive Care Medicine, and Society of Critical Care. Multidisciplinary, even international. I thought it was awesome that nurses were included in this conversation. So what did it say? It says that it has a plan. There's 4 categories of disputed treatments in the ICU, and for each plan, I'm going to tell you about the 4, but I can't tell you exactly the process, but there's a process and a procedure how you handle it if it's this kind of dispute versus this versus this, okay? So here we go. The first type of treatment dispute might be a request for actually futile, ineffective treatments. The only time they use futile in this policy is if it's truly medically, physiologically, it won't work, right? Everything else, when it kind of could work and it's kind of gray and messy, this is a situation, and they define it as the intervention cannot accomplish the intended physiological goal. And then it goes through a process for how you would resolve that. Now these other ones are when it's not physiological, it's different. This is the second type. This is the important part of the whole article is potentially inappropriate treatments. Now these are treatments, and I'll just read to you, that have at least some chance of accomplishing the effect that is sought by the patient or surrogate, but the clinicians believe that there are competing ethical considerations which justify refusing the requested treatment. Let me give you a couple examples. So maybe this clinician says, I don't think we should admit this person to the ICU. They have end-stage dementia and multi-organ failure. Do you think that might be a spot where, even though it might have an effect, that maybe ethical issues might say we shouldn't? The nice thing about this is you don't have to have the answer. The process and procedure gets you to the answer, right? Because they're always contextual. What about dialysis for someone with PVS? Is it inappropriate to continue mechanical ventilation for someone with widely metastatic cancer? These are the kinds of things where it could have an effect, even an effect that the patient might want, but the doctor's a little concerned, so maybe we need to go through the ethics committee, etc. Okay? The next topic, the third type, are requests for potentially inappropriate treatments, similar types of treatments, in time-sensitive situations. These are situations where you do not have time to meet with the ethics committee, get a second opinion, all the things we need to do to resolve the conflict resolution. So this is a situation with rapidly deteriorating clinical condition, and here's the language to be aware of. This is when a clinician has a high degree of certainty that the treatments requested are outside the bounds of acceptable practice. Right? Other doctors wouldn't do it, so I shouldn't do it. I love these questions that they provide. These are questions that I think you could use in all sorts of situations. These are questions for yourself, not that you ask someone else. These are for you. To evaluate the moral issues from your perspective. Am I certain that this requested treatment is outside the bounds of accepted practice? How certain am I? Because, right, it has to be a high level of certainty. And if I am certain, would I be willing to have the rationale for my decision be publicly reviewed in an appeals board or a court? Right? How certain are you, right? Because if you're going to take a certain action, you better be confident, because this is a time-sensitive situation where we don't have all the steps in place. Also, make sure you're documenting, right? Document your thoughts regarding this. What are the consequences to the stakeholders? We always think about the patient. Sometimes we think about the surrogate. How about the team? What are the consequences to this decision for the team and the institution? Those are, don't just try to think of it all at once. Stop and ask about each category of people that are stakeholders. Also, am I sure that sex, race, socioeconomic, ability to pay, other psychosocial factors aren't affecting my judgment and this decision? Right? Because, well, she can't pay, might be easier. No, wait a minute, we're not supposed to use that. I love these moral questions because they check on us. Because a lot of times we just do what we've always done, or we already think we know the answer. This makes us stop and evaluate, am I certain enough that I'm willing to stand up and say it out loud in front of the board or the court? The last situation are disputed treatments that are legally prescribed or legally discretionary. So this might be something where in our state, we don't have a physician-assisted suicide bill. So other people want us to do that, and that's against the law. I can't do that. Or, you know, the organ donation, there's a certain order that we take people in. I can't just jump you to the front of the line, right? So there's things where the law supports us in saying no, right? And in those situations, it's not for us to resolve. We have to go to court. Right? But again, knowing what kind of issue you're dealing with and the structured way that you can resolve it is very helpful. And because it's a system-wide, hospital-wide approach, it also gives you the support of the institution, which I think can be really helpful in these challenging moments. The last thing I brought you, because I'm pathologically helpful and I like to bring you lots of tools and resources, is an ethical process and structure that's been around for decades. It's called the 4 boxes, and this is developed by Johnson, who was a philosopher, Siegler, who was a physician, and Winslade, who was a lawyer, which was kind of cool, right? How we've been talking about different points of view. It's 4 boxes. You actually have them in your handout. I've given you a copy of it. You can always just download it from the internet. And the 4 categories are questions that we should be talking about medical indications, right? Medicine matters. Patient preferences, absolutely. We've got to learn about that category. Quality of life and contextual features. It doesn't tell us the answers, but it reminds us to collect knowledge in this situation from those 4 categories. The problem with this 4-box approach is we don't have the answer. Which box wins? You have information from each category. Which box wins? Does the patient win? Does the medical win? Right? But again, it helps us make sure that we're asking a more inclusive overall approach to these challenging ethical dilemmas. I have also included in your handout a second type of 4 boxes, and that has values questions. It also has a nice set of questions regarding stakeholders, because a lot of times when we're starting to think about justice and what we should do as an institution, not just for this patient, but organizationally, these types of questions can help us process as a committee, subcommittee, organization. So I'm not going to go through it, but that's how the first form looks, and that's the second one. So lastly, I've given you a little cheat sheet of questions you can use to begin these ethical conversations, right? Because there's no way you can become a legal expert. You're not bioethicists. You can't be experts, but I can give you a set of tools where you can shortcut the process and make sure you're asking a nice set of holistic questions, right? I do not have the answers, but in bioethics we have fabulous questions which help us look at things from multiple points of view. Right? And I do like that new policy, that joint policy, because it also reminds us to look at our own point of view and see how that's playing out in the situation. So with all these different tools, this should help you start structuring your conversations. And keep in mind, as we mentioned right at the beginning, the personal matters, the legal matters, and the ethics matters. So make sure you look at all of those pieces. Thank you very much. I appreciate it.